Hi, I'm Shireen Smith, taking a look at logo design protection today. Using trademark, design and copyright are the ways to protect logos. The subject isn't well understood, yet it's worth paying attention to because protecting your business matters. To understand the available legal protections for logos, first, let's look at examples of the different types of logo that you may want to protect. Now, there are three variations. Firstly, a combined mark, that is, a word and image that looks like this. The words incorporated within such a logo should be checked for trademark purposes before using the logo to make sure it's not already trademarked by a competitor. This is necessary even if you've already registered the company or domain name. As a separate matter, also have a trademark search to check that the image element isn't similar to a competitor's trademark too. Secondly, a stylized mark. That means a word on its own like this. Now, the words incorporated within such a logo should be cleared for trademark purposes before using the logo to ensure it's not already trademarked by a competitor. This is necessary even if you've already registered the company or domain name. And thirdly, there's device marks. This is an image on its own, rather like the Nike swoosh. Now, all these different manifestations of a logo are capable of being protected, not just with a trademark registration, but also with design registration. Now, copyright is fundamentally important, that you should start there and make sure that you've got the rights in your logo. That's essential. So the three intellectual property rights relevant to logos. Logos such as signs indicated above that also can be protected in at least one of three ways, as I've explained. The rights need to be taken on board before commissioning anyone to help with your brand identity. If you're to own the necessary rights in your brand, then you'll need to look into the three intellectual property rights in more depth than this piece goes into. Copyright, registering designs, and registering a trademark. So, copyright protects works such as logos, graphic designs, drawings, photographs, etc. In most countries worldwide, the copyright in these visuals will vest in the creator unless they're your employees paid through the payroll or they transfer the rights to you in writing. People hear that copyright arises automatically and doesn't need to be registered, and are then lulled into a false sense of security. They're not aware that the ownership rules under the law don't necessarily vest copyright in them just because, they're paying for the work to be created. Now, while it's not necessary to register copyright in the UK, in some countries it is, and in the USA it's established practice to do so, such as through the Library of Congress. Now, copyright is a most powerful right to own, and you need to own it, but the serious drawback with it is the need for proof of ownership and copying. Now, to stop someone using an identical or similar logo on their website, say, you need to prove that they actually copied your logo. They may argue you copied theirs, or that they came up with the same logo independently without copying yours. In that case, you then have an expensive dispute because it's necessary to look at the evidence and establish who is the true creator of the copyright work. Now, if the matter went to court, a judge would need to decide by looking at all the evidence. So, once you secure copyright ownership, if you register your logo as a copyright, which you may do and must do in some countries, then it's one of the ways of establishing proof of the date of creation of the logo. This may sometimes be sufficient to resolve a dispute speedily. Now, evidence that would be acceptable to a court of law also includes use of a statutory declaration. However, posting an envelope to yourself is not acceptable. That's because it could be argued that you tampered with the envelope after it was posted. Now, even where you have satisfactory evidence of the date of creation of a logo, it's still necessary to prove that the other person copied your logo and didn't happen to come up with the same design independently. Now, registered design. Given that logos automatically have copyright protection, the benefit of registering a logo as a design is that the registration certificate acts as proof of your rights. It then becomes immaterial that the other party may have come up with a similar design, unless they can prove that they'd done so before you registered your design. In that case, they would be applying to invalidate your design registration. So registering a design gives you more powerful rights in the logo than copyright alone, as it addresses the problem of proof of the date of creation. Registration of logos as designs can therefore act as a good deterrent to copying. Design registration is available in the UK, in the EU, or via The Hague internationally. Once registered as a design, you may renew the registration every 5 years for up to 25 years. It's necessary to register the logo in a short time window, a year, so it's worth dealing with design registration early on. Note that in the USA, copyright registration gives you the equivalent of registered design protection, as their design protection is more relevant to patents. Now, trademarking a logo. Trademarks are tools to protect the reputation and goodwill of a business. They enable your customers to recognize your products and services and to distinguish you from your competitors. The image element should be cleared, searched, in other words, for trademark purposes, to ensure it's not too similar to a competitor's trademark. While the word element also needs to be searched, as I've explained before. Now, as trademark registration is often what people ask about, I would just say that what you register as a trademark depends on how you use your mark in practice. For example, if you use it only as a combined mark, then a single combined registration is sufficient. If you use the elements separately, then you should register each one separately as well as in combination, so 3 trademarks. For those on a strict budget, then register the word on its own or a combined mark, depending on your business, and then later apply for the separate elements. Now, registering a trademark is the way to secure exclusive ownership of your unique brand signs and to protect your business against competitors who use similar names or signs to take business away from you by promoting similar products and services. Now, while in the UK and USA, rights in trademarks can be built up through use of the mark, In most countries, the first person to register is the one with rights to a mark. Indeed, even in the UK, if someone else has registered the trademark before you, then you would need to rebrand. Bear in mind that passing off disputes to establish your use rights in a name are extremely expensive, time-consuming, and really messy. In practice, it's just very difficult to argue that you have earlier rights in a name due to the hurdles that the law puts in front of you. So register your brand as soon as possible, unless you're not attached to the name and are just using the name temporarily to test your proof of concept. Now, protecting logos, in conclusion, for those with the resources, the best approach is to register both design and trademarks. Having both types of registration gives you a level of protection that increases the range of situations in which you can stop others stealing your intellectual property. Design registration protects logos in ways that trademarking the logo just doesn't. For example, say someone is using your logo on their website for a non-competing business. Say it's a porn site. Now, your design registration would be a powerful intellectual property right to require the website to stop using the logo. Copyright alone has the problems I've mentioned earlier of proof and so on. The trademark registration wouldn't help you in that situation because trademarks only stop other people using the same sign to sell similar products and services. If there is no customer confusion or sales involved, as in the example I just gave, then the trademark would be totally irrelevant. Note that I'll be doing a live cast on the 30th of January to discuss the commercial drivers when engaging designers to create a brand identity, and I'll also look at the contractual arrangements you should put in place with them. You may register to attend the live cast and ask your questions.